So what I'm going to do today is explain what this law is for those of you who aren't familiar with it and how it works. The Tennessee law, what it does, it's not like a separate criminal law. It modifies the existing Tennessee law on assault. So this is the kind of summary of what a simple assault is under Tennessee laws. A person commits simple assault who intentionally, knowingly, or recklessly causes bodily injury to another. And so the important word in that is the word another, because that's what was modified. The statute originally also at one point was amended to define another, to include not only an individual or another person, but also an embryo or fetus. That would then apply to anyone who commits this intentional or knowing harm to another if they also harmed an embryo or fetus. But what the Tennessee General Assembly had originally done was to add an exception to the assault law. And that exception said that nothing in simple assault shall apply to any act or omission by a pregnant woman with respect to her embryo or fetus. So essentially that allowed or that prohibited a prosecution from charging a woman with simple assault for any act she took or omission, whether it was ingestion of legal or illegal substances with regard to her own fetus or embryo. So that was the state of the law before this new law came to effect in April of 2014. So what did this new law do? Well, and there you have essentially explaining the exception. But the new law, which you see the first section, it did two things. First, it modified that provision, that exception, and added the word lawful before act and omission. So whereas before it said any act or omission, now it says any lawful act or omission. We're not seeing this part of the law used terribly much because they added a second provision that specifically applies to pregnant women. So this is the second section of the bill or the law that was passed, and this adds this provision that says that nothing in the assault law will preclude the prosecution of a woman for illegal use of narcotic drugs, which is a very specific phrase, while she is pregnant with her child, and the child is born addicted, which I'm sure we'll talk about that throughout the day, whether that has any meaning or not in this context, or harmed by the narcotic drug. And again, you see narcotic drug used twice in that statute. The law then also added this, you'll see in section 3 there, an affirmative defense to this charge. An affirmative defense, for the non-lawyers in the room, means that the defendant has the burden of proving the elements of this defense, and if she is able to do so, then she would be acquitted of the charge. And the affirmative defense essentially says if the pregnant woman enters treatment before the birth of the child, remains in treatment, and successfully completes the program, then she would be acquitted of the charge of assault. So that was the new amendment. So like I said at the beginning, it didn't really create its own little kind of new criminal law. What it did was modify and amend the existing assault laws in a somewhat, in my opinion, confusing fashion to allow prosecutors to start bringing charges against women for use of drugs during their pregnancy. A couple of things just to kind of note about the way this has been, how this statute has been written and how it would have to be applied. First, since it only applies to a woman whose child was born harmed by narcotic drugs, the prosecution should happen only after a birth. it would be, not all drug use, prenatal drug use leads to harm to the child. So if there is no harm to the child, the way the statute reads, there should not be a charge that can be brought. Second, the use of the term or the phrase illegal use of narcotic drugs. Narcotic drugs have, or a narcotic drug has a very specific definition in the Tennessee statutes. So when this was written originally, it only included those drugs defined as narcotic drugs, which include most of your opiates, heroin, morphine, Oxycontin, or other opiate painkillers, as well as marijuana for some reason, but not methamphetamine. So the statute originally as written should not have been able to be used against someone who was using any other drug other than something that is classified by the statute as a narcotic drug. The other, I guess, interesting point about this statute there in the affirmative defense, it talks about an addiction recovery program. That is not defined in the statute or in the code at all. So when I first read this bill, my first question is, what is an addiction recovery program? Because if we're going to allow women to prove their own affirmative defense, what do they have to prove? Is it enough for them to prove, well, I went to, some sort of meeting, some sort of 12-step program, an NA meeting, and then I continued that and I completed it. How do you complete a 12, that type of program? Or do you have to go to an outpatient or inpatient program, some sort of residential program? Does it have to be a program that is geared toward pregnant women? Can it be any kind of program? Can it be a faith-based program? Does it have to be a program that anyone's ever looked at and said, yes, this works? So that's very unclear. Unfortunately, we don't know how it works because I don't believe that anyone's ever actually employed this affirmative defense so far in the prosecutions that we're aware of in the state of Tennessee. So that'll bring me to the last kind of part of my little opening presentation, where we know there were 28 prosecutions in 2017. Excuse me. We know that because the Department of Safety did a survey of all 30 district attorneys in the state of Tennessee, and about 27 or so responded saying they had 28 prosecutions. Those 28 prosecutions, though, were only in 10 of the 31 judicial districts. So this is not being applied very evenly across the state. Two of the districts that have the most prosecutions in 2014 were Sullivan County and Shelby County, which also happened to be two of the districts where district attorneys were proponents during the enactment of this law. So we kind of figured that since they were in favor of the law, they would also be in favor of using the crime, or using the law to prosecute. The other interesting thing is that of those 27 or so district attorneys that responded, 17 say they believe the law has been helpful. 7 said they did not believe the law was helpful at all. There were comments. Some of the DAs worried about some of the concerns that we had, such as whether this would drive women away from prenatal care. And some actually, honestly, I think didn't believe the law was harsh enough, and so they didn't think it would be helpful. So those 7 aren't all concerned, people concerned about how this law affects pregnant women in the negative. But anyway, so that's kind of the nutshell of what this law does and what we've seen, at least from the hard data. What we know from anecdotal data or information is there's been several more prosecutions in 2015. I guess we've just started the 10th month. I know personally of 15. There's probably double that, if not more. We know that it's not being used, still not being used evenly across the state, and we suspect but can't prove that it's probably only affecting women who are living below the poverty line or who are qualifying for indigent representation. So hopefully those types of data will become more available shortly, so that when this law comes up for renewal, It sunsets, meaning the law goes away in July of 2016 unless the General Assembly renews it. So we will have an opportunity in the winter to defeat this and get it off the books again.